Welcome to Immigration Quicktake. This is Ellie Rutledge Silver with the American Immigration Lawyers Association. AILA and the American Immigration Council have petitioned the federal government to issue rules that will ensure that access to legal counsel is understood to apply across the spectrum of immigration proceedings. Here to share details of the petition is Betsy Lawrence, Director of Government Relations at AILA. Betsy, thanks for joining me. First, why are the AILA and the Council petitioning?
Thanks, Ellie. So access to counsel in immigration proceedings has been a long-standing issue for both AILA and the Immigration Council. And a few years back, we stood up an Access to Counsel task force to specifically take a close look at the lack of attorney access in consular interview settings and during the CBP admissions process, and to come up with a strategy for advocating for change in these areas. So the group considered a number of different options and ultimately settled on a petition for rulemaking. So simply put, a petition for rulemaking is a request that any individual or organization can make to the government to ask them to amend or issue or repeal a rule. So in this case, the lack of access to counsel has created many obstacles for individuals, employers, and organizations who are seeking visas or admission to the United States. And the hope is that this petition will compel the U.S. government to issue a new rule that would facilitate access in these areas.
What difference does counsel make during proceedings?
The presence of counsel in Department of State consular proceedings and before CBP can have a tremendous impact. U.S. immigration laws are notoriously complicated, and there are many layers to determining whether an individual is eligible for a visa or for admission to the United States. The presence of counsel can help facilitate that process and help ensure that a correct decision is ultimately made. I think at no point in time did this become more apparent how important this issue is than in the immediate aftermath of President Trump's first executive order on immigration that dealt with the travel and refugee ban. The U.S. airports erupted into chaos, and AILA lawyers from around the country flocked to the airports in an effort to help ensure that the legal rights of individuals who were seeking admission to the United States, and in many cases were lawfully entitled to be admitted to the United States, and to ensure that their rights were protected. CBP sometimes permits attorneys access to the secondary inspection areas, but there's a regulation on the books that often stands in the way. If attorneys did have access to their clients in secondary inspection, many people who were needlessly turned away, and in some cases even asked to surrender their green cards, would perhaps have been admitted, but at a minimum, they would have been assured that their legal rights were protected.
What happens next?
So the petition has been filed, and we need to give the government time to respond. The Administrative Procedure Act, which outlines the rules for requesting a petition for rulemaking, requires the government to respond in a, quote, reasonable time frame. If the government doesn't respond within a reasonable time frame, the petitioner can sue to compel action on the petition. So at this point, we're in a little bit of a wait-and-see mode. But before we go, I just want to give a big shout out to the Access to Counsel Task Force, and in particular Brent Rennison, who worked tirelessly on this petition. And thank you, Brent. We could not have done this without you.
Thanks, Betsy, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.